Hello, welcome to the OADC webinar, Analyzing Claims of Traumatic Brain Injury and Post-Concussion Syndrome. My name is Sheila Cieslik. I am Senior Staff Attorney at American Family Mutual Insurance Company and also the Chair of the OADC Trial Practice Group. I will be moderating today's presentation. I'm pleased to introduce our presenters today, Dr. Lawrence Binder and Eric Keckel. Dr. Lawrence Binder is a psychologist and is board certified in the specialty of neuropsychology. He has practiced in Oregon since 1980. He formerly served as the director of postdoctoral training in clinical neuropsychology at the Portland VA Medical Center. Throughout his career, he has engaged in both clinical practice and research. He is the author and co-author of more than 80 papers in peer-reviewed scientific journals on neuropsychological assessment topics, including assessment of performance and symptom validity, exaggeration, outcome after mild traumatic brain injury and post-concussion syndrome,
in progress,
normal variability in cognitive performance, effects of military blast injuries, and medically unexplained symptoms including Persian Gulf War illnesses, psychogenic non-epileptic seizures, and others. He was named a Fellow of the Society of Clinical Neuropsychology of the American Psychological Association and the National Academy of Neuropsychology to honor his outstanding scientific contributions to the field of neuropsychology. Eric Keckel is a partner at the Dunn Carney Law Firm and leads the firm's insurance defense team. He has been an insurance defense litigator in Oregon and Washington since 1992. Eric's practice focuses on the defense of catastrophic personal injury, products liability, construction defect, and a variety of commercial litigation matters. He has defended mild TBI claims arising out of cases involving slip and falls, products liability, worksite accidents, and motor vehicle accidents. In March of this year, Eric and his partner, Don Templeton, defended a mild traumatic brain injury case through an 8-day trial in Clark County. I want to thank both Dr. Binder and Eric for being willing to appear via Zoom to present today and to field your questions. Before we get started, I'd like to quickly walk through some of our housekeeping items. Your microphones and videos are muted for this webinar. To ask questions, please enter it into the chat section. We will monitor the chat section and ask questions of the presenters on your behalf. Please feel free to submit your questions at any time. We will try to answer as many of the questions as possible, but due to the limited time available, we may not be able to get to all of your questions today. We are applying for CLE credits. We are recording this presentation and we'll be making it available at a later date. We plan to circulate the presentation materials, details on how to receive CLE credit, and our contact information via email after the webinar. So with that, we'll get started on the program. Thank you.
Thanks for inviting me to be here. If my introduction went on too long, blame me because I wrote it. I'm going to talk mainly about concussion and mild traumatic brain injury and post-concussion syndrome. Concussion, the terms concussion and mild TBI are synonymous, and I'm going to say almost nothing about injuries to children today. This is one classification of severity of traumatic brain injury. This classification was developed jointly by the Department of Veterans Affairs and the Department of Defense. And so looking at the top row, you can see that injuries can be defined as severe or moderate, even if the brain imaging, the MRI, the CT scanning, is normal. focusing on the mild traumatic brain injury column, loss of consciousness can be up to 30 minutes, anywhere from 0 to 30 minutes. Alteration of mental state, that is confusion, can last up to 24 hours. Post-traumatic amnesia, meaning the interval when the patient is unable to lay down new memories, that can last up to 24 hours. And the Glasgow Coma scale score, whereas a perfect score is 15, it can be as low as 13 and still be in the mild category. So you can see that the mild category covers a wide range. And I don't think any of us would want to sustain a head injury with 30 minutes loss of consciousness or alteration of mental state as confusion lasting 24 hours. So all I want to say about severe traumatic brain injury is that variable is outcome. Sometimes the outcome is surprisingly good. You may want to wait to settle your cases until you know whether or not the plaintiff is going to be able to go back to work, because they can fail at their pre-injury jobs, or if they change jobs and have to learn new job tasks, they can fail at those new jobs. Also, the risk of dementia later in life is increased by moderate traumatic brain injury and severe traumatic brain injury. So now the focus is only on concussion, aka mild traumatic brain injury. There are varying definitions, and whether concussion is diagnosed depends on the definition of concussion. If concussion is defined only by symptoms, the common ones, most common ones being things like headache, dizziness, mental fog, sometimes blurred vision. If concussion is defined only by symptoms, then people who are not concussed will be diagnosed with concussion, because no symptom is specific to concussion or diagnostic of concussion. And if you get medical records that pre-exist your injury, you'll often find complaints such as headaches, dizziness, nausea, mental fog, and so on in those pre-existing pre-concussion medical records. So here are the criteria for concussion or mild traumatic brain injury issued jointly by the VA and the Department of Defense. So you got to have any period of loss of consciousness or decreased level of consciousness. The person does not have to be unconscious. It can be defined by retrograde amnesia, that is, the person can't remember a few seconds or a few minutes immediately preceding the accident, or more commonly, post-traumatic amnesia, that is, inability to lay down new memories immediately after the head injury. It can be defined by any alteration of mental state at the time of injury, that is, confusion, disorientation, slowed thinking. When a Glasgow Coma scale score is not a perfect 15, and is only 14, that's almost always because of disorientation. Mild TBI can be defined by neurologic deficits such as loss of balance or change in vision. Often those are transient. It's, in my experience, it's very rare for neurologic deficits to appear in the medical records. But they're probably more commonly found when people are evaluated immediately after their injuries. For example, right after a football concussion, there's sideline evaluations. A brain lesion, that is an abnormal CT or MRI of the brain, defines a traumatic brain injury. Person doesn't have to have a blow to the head to have a concussion or mild traumatic brain injury. In the military, blast injuries, explosions can cause mild traumatic brain injuries. And whiplash, if it's severe enough, can cause a mild traumatic brain injury. The DSM-5 text revision define minor neurocognitive disorders due to traumatic brain injury, and also major neurocognitive disorders. So in order for the person to meet criteria due to either major or minor neurocognitive disorder due to TBI, they have to meet the criteria for major or minor neurocognitive disorder. They have to have cognitive deficits compared with pre-injury baseline. There has to be evidence of traumatic brain injury, and their neurocognitive disorder presents immediately after the injury or immediately after the return of consciousness and persists past the acute post-injury period. So according to DSM-5 text revision, the latest version of DSM-5, subjective symptoms do not define a traumatic brain injury concussion. Well, my screen is frozen and I'm not able to advance. There we go. Okay, so the American College of Rehabilitation Medicine finally revised their definition of concussion. The old one was 30 years old. And usually if an injury meets the definition of the VA-DOD, it will meet the ACRM definition. But the ACRM definition is broader than the VA-DOD definition. So the ACRM definition requires 2 symptoms plus 1 acute objective abnormality, for example, balance, cognition, or eye movement abnormality that clearly is a change from pre-injury status. In the future, but not now, there may be laboratory abnormalities, for example, blood or cerebrospinal fluid abnormalities that define a TBI, but those type of laboratory measures are now in the experimental phase. And again, if brain imaging is abnormal due to the head injury, then that defines a traumatic brain injury. So there are a lot of problems with the diagnosis of concussion. First, the diagnosis or the non-diagnosis of concussion. That diagnostic decision often is made in an emergency setting, but emergency room physicians, they're trying to rule out catastrophic injuries. They're not concerned with subtle distinctions between quote head injury or quote concussion. So the diagnostic label may not be precisely accurate. Sometimes they practice very defensively for obvious reasons, and so they order brain scans when brain scans probably aren't necessary, and they may have to make a diagnosis that justifies the brain scan that they've ordered for defensive purposes. Their neurological exams are extremely cursory, very brief, compared with what a neurologist would do in their office, and so they may not find objective abnormalities that might actually exist. And then if you're looking at concussion diagnosed well after the date of injury, well, that may not be as accurate as a diagnosis made right after the injury, the day of the injury, assuming the assessments are equally thorough. So when you look at records, it's often difficult to confirm or disconfirm concussion. But the good news is that the outcome after mild concussion is good. And the vast majority of cases that I've reviewed and examined in medical legal arenas, the concussions are mild, if there was any concussion at all. The biggest problem with the diagnosis of concussion is that the symptoms of concussion can occur for many reasons other than concussion. That is, the symptoms of concussion are not specific to concussion. And if concussion is defined only by symptoms, then there will be false positive diagnoses. So I want to go over real briefly studies that are favorable to the plaintiff's side and point out why these studies can be, well, they're subject to cross-examination because they may not apply to your case. So a study done by Dickman and colleagues 6 years ago up at the UW She and her colleagues found evidence of persisting symptoms after what they defined as mild traumatic brain injury. But all the participants in that study were hospitalized, and many of them had abnormal brain imaging. What they found is that a year after the injury, people with mild traumatic brain injuries, that is concussions, had more symptoms compared with controls who had injuries to other body parts. And about half of the people with concussions had 3 or more symptoms versus about a quarter of the injured control. So first of all, this study dealt with hospitalized patients, and they're not equivalent to the most people that I see, and probably most people that you see who have been diagnosed with concussion, who didn't require hospitalization. In this study, many of the participants had Glasgow Coma scales scores less than 15 or abnormal brain scans. And many controls were symptomatic, which demonstrates that brain injuries did not cause all the symptoms in the brain injured group. The control group in this study were people who had traumatic injuries, but not traumatic injuries to their head or brain. There's a big group of researchers, and they call themselves the TRACK TBI group, and they've put out many studies. And these studies show persisting symptoms, and these studies often do not apply to the people who come onto your desk with reporting concussions. These TRACK TBI studies do show persisting symptoms, as did the UW study I mentioned in the last slide. But again, the sample used in these studies includes many with brain imaging abnormalities, many who are hospitalized, many with significant physical injuries, many with prior psychiatric histories, and in fact includes only those who were seen in hospitals. And the TRACK TBI studies did not assess performance validity. So the outcome after concussion, first of all, there's often inconsistency between subjective complaints and objective findings. The subjective symptoms sometimes persist, and as demonstrated in the previous slides, they especially persist in people who are hospitalized for their injuries. There's no good scientific evidence of objective cognitive abnormalities demonstrated by neuropsychological testing persisting more than 90 days after the date of injury. And that lack of good scientific evidence has been demonstrated by repeated meta-analytic studies. Meta-analytic studies are quantitative reviews. So symptoms of concussion are not specific to concussion. And that is the big take-home point of my talk. So something about migraines, prior migraines. Migraines are very common in the general population. So here's a study that looked at the effect of prior migraines on athletes. Migraines are often alleged to be caused or exacerbated by concussion. But in this study, athletes, their return to play and their return to school was unaffected by prior migraine history when they lumped together males and females. There was some effect for females. Vision. Now, I'm not a neuro-ophthalmologist, and when there are vision complaints, I recommend that you obtain an expert neuro-ophthalmologist. But I cited here a couple of studies that showed lack of evidence for vision problems after concussion. The so-called post-concussion syndrome refers to nonspecific symptomatology that persists after alleged mild traumatic brain injury. There's no time interval that defines when symptoms of concussion become a post-concussion syndrome. Is it a week, a month, 3 months? I don't know. There's no agreement. Post-concussion syndrome is, a syndrome is a group of signs and symptoms that occur together and characterize a particular abnormality or condition. post-concussion syndrome is not a true syndrome because there's no widely accepted pathology and because the symptoms following concussion are not specific. Still, you're going to see the term post-concussion syndrome used all the time, and in some cases, it is appropriate to use that diagnostic term, but there are problems with the term. Perfectly healthy, non-injured people have post-concussional symptoms. And in two different studies, these were the rates of various symptoms. Wide variability between these two studies. Vision problems, for example, occurred in 2% in one study and 40% in another study. Balance problems were reported by 3% of the sample in one study and 14% in the other study, and so on. But all these studies are known to, all these symptoms are known to occur in non-injured people: headaches, dizziness, light sensitivity, word finding, concentration, forgetfulness, temper outbursts, anxiety, depression. The non-injured athletes, 16% of them met ICD-10 criteria for diagnosis of post-concussion syndrome. They had not been injured. These were Division I athletes at the University of Florida. Post-concussion syndrome often is linked with prior psychiatric problems and injuries to other body parts. So here's a study that, again, used non-head injured trauma controls and compared them to people who had suffered mild traumatic brain injuries. So when post-concussion syndrome was defined as 3 or more symptoms, such as memory loss or dizziness or headache, there was no difference between the number of people who had, quote, post-concussion syndrome in the people who had head injuries versus the non-head injured control group. 43% in both groups. So 43% of the people who had been injured but not head injury, that is the control sample, met the criteria for the diagnosis of post-concussion syndrome. Now, I'm going to throw one statistic at you. OR stands for odds ratio. So if you think about the association between a history of smoking and lung cancer, in some studies, the odds ratio is 20, meaning that people who smoked have a 20 times greater risk of developing lung cancer than people with no history of smoking. So in this study, the strongest predictor for post-concussion syndrome was a pre-injury diagnosis of either a mood disorder, meaning usually depression, or an anxiety disorder. So the odds ratio was 5.76, almost 6. People were almost 6 times as likely to get a diagnosis of, or to qualify for a diagnosis of post-concussion syndrome if they had a prior mood or anxiety disorder, regardless of whether or not they actually sustained a concussion. And in this study, females were more likely than males to have post-concussion syndrome. And this study is dealing with the acute phase within 14 days of injury. But here's a study by the same investigators looking at post-concussion syndrome later, after a mean of 106 days after injury. So again, there was no significant difference between the rate of post-concussion syndrome between the people who had head injury and the people who were injured but weren't head injured. And also, it's really interesting that almost 39% of all the post-concussion syndrome cases were new at time 2, compared with time 1, which was within the first 14 days. In other words, there were all these people who didn't qualify for post-concussion syndrome within the first 14 days, but around 3-4 months after their injury, all of a sudden, they qualified for post-concussion syndrome, regardless of whether or not they had a history of head injury. So this study really illustrates how nonspecific the symptoms are to post-concussion syndrome. So again, another study that shows that people with other injuries, people with traumatic injuries that were not head injuries, they meet criteria for post-concussion syndrome when post-concussion syndrome is based just on the existence of symptoms and not on history of actually sustaining a head injury, a concussion. So in this study, 28% of people with concussion had post-concussion syndrome, but 21% of people who had traumatic injuries that didn't affect their head also qualified for the diagnosis of post-concussion syndrome. So in this study, the risk of post-concussion syndrome was only 1/3 higher in the group who had concussions compared with the people who had injuries to other body parts. Meaning that if you didn't know whether a person had a concussion or not, and the person had symptoms of post-concussion syndrome, the best bet would be that the person didn't have a head injury. And that's how the statistics shake out. That's the implication of the statistics in this study. Here's another study. This study was done on veterans, veterans of the wars in the Middle East. And I want to focus here on well, let's go to this first column. This was the frequency of post-concussion syndrome by diagnosis. So people who had a history of mild traumatic brain injury, 27% of them in this study had a diagnosis of post-concussion syndrome. But people who had PTSD, but no traumatic brain injury history, 39% of them had the symptoms that qualified for a diagnosis of post-concussion syndrome, and so on down this column. People with anxiety disorder, 41% met criteria for diagnosis of post-concussion syndrome, even though they didn't have a history of head injury. Depression, 55% combination of depression and mild traumatic brain injury. That was really high, 74%. Combination of PTSD and mild traumatic brain injury. That was really high, 75%. And so on. So the highest one was somatization, 91% met criteria for diagnosis of post-concussion syndrome. And these columns look at specific symptoms, headache and dizziness. So people with somatization, they were almost 20 times more likely than controls to have headache, and they were 37 times more likely to have complaints of dizziness. So, the headache and dizziness, those are two of the cardinal symptoms of post-concussion syndrome, and yet they're very common in people with PTSD, anxiety, depression, and somatization. So can symptoms of post-concussion syndrome go away for some interval and then return out of the blue? And if so, what's a reasonable amount of time to conclude that the initial concussion remains causative of the symptoms? So this is just my opinion. This is based on my clinical experience, not really based on solid published research. In my experience, symptoms may recur because of a triggering activity, for example, heavy lifting or prolonged screen time. And if those activities are new since the injury, the concussion could be the cause. So more data on the non-specificity of symptoms after concussion. Symptoms that can be attributed, that might be attributed to post-concussion syndrome, they are associated with an increased risk of mild traumatic brain injury. What I'm saying here, what these studies showed is that when medical records showed that before people had any head injury, they had pre-existing symptoms of mild traumatic brain injury, of concussion. In other words, before their head injuries, they had symptoms like headaches and dizziness. Those people, interestingly, were more likely
It appears as if Dr. Binder has frozen up. Eric, I don't know if you want to take over for here and I'll try to get him back on.
Oh, whatever works best for the group.
Eric, I think you should take over.
All right. Sec. Okay, can everybody see my screen? Sheila, can you see it?
Yeah, it looks good.
Perfect, thank you. Well, good afternoon, everybody. Again, I'm Eric Keckel, and we're going to talk, I'm going to piggyback on what Dr. Binder was talking about. These are the areas that I'm going to try and cover today, and these are some of the minimum tasks and things that the defense attorney should be doing when defending a mild traumatic brain injury claim. We'll discuss each of these in a bit more detail, but it is extremely important that you obtain all the pre-incident medical records. As you heard Dr. Binder say, most people are experiencing concussion type symptoms, if you will, prior to any type of incident. So it's important to know the plaintiff's entire medical history. Similarly, obtain all the pre-incident psychological records. Many people who have claimed a mild traumatic brain injury in some form of accident have a psychological history. So you want to make sure and get those. Same with employment records. You want to get all their employment records as far back as you can go, because you will find in many cases that the plaintiff has had difficulty with employment prior to any of these incidents. This is going to also help you determine the experts that you need. We're also going to talk a little bit about some of the learned treatises that plaintiffs rely on to support their claim, and to the extent we have time, talking about the overcoming the eggshell plaintiff theory. So again, very important to obtain all the pre-incident and medical and psychological records. So do not rely, and many of you here are very experienced defense attorneys, and this is nothing new to you, but don't rely on the plaintiff to provide you the records. Go after them yourselves. Use authorizations or subpoenas and get everything. When you get all the medical records, these are some of the things that you want to look for. You have heard Dr. Binder, he said that many of these people have post-concussion type symptoms before any asserted incident. So some of the things you want to look for here in the medical records are history of depression. Many of you probably know what the PHQ-9 test is, if you will. It's a series of 9 questions. It is designed to identify whether someone has depression. It's on a certain scale. Each question has a number. A score of 15 to 19 is moderately severe depression. A score of 20 and above is severe depression. So know your PHQ and what it means. Same, look for anxiety. Look for in the medical records whether a GAD-7 has been given to the person. That's a general anxiety disorder. 7 questions. Any score above 10 to 14 is moderate anxiety, and anything greater than 15 is severe anxiety. So you're going to want to know those. Post-traumatic stress disorder. Look for whether a PTSD-5 or other type of test has been given. Pre-incident. You're looking for all this stuff pre-incident. Look to whether the person has a history of ADHD, obsessive compulsive disorder, OCD, body dysmorphic disorder, BDD, whether there's a history of vision issues. Pay attention to the medical records where the doctor takes a social history. You can get a lot of nuggets out of there, and look for work-related issues. And then you're going to want to list out all the symptoms that you're finding in the pre-incident medical and psychological records. And I like to, identify the number of times this particular plaintiff complains of each of these problems pre-incident. And that's going to help you identify the experts that you may need. Again, all the pre-incident employment records. Don't rely on the plaintiff, and some of the things you want to look for. Is there a history of discipline prior to the incident? Were there frequently days missed prior to the incident? Did this plaintiff have frequent changes in employment? And you can find hints in the employment records of potential anxiety or inability to concentrate of this particular plaintiff, all pre-incident. These are all helping you as a defense attorney get clues that you will need in order to cross-examine the plaintiff's experts. Okay, now let's talk about some of the experts that may be needed, and Dr. Binder can jump in here as well. So concussion, MTBI, most of you know this, you're going to want a neurologist and either a psychiatrist or a psychologist. If there are mental health issues that are being alleged and that you find pre-incident, then you're going to definitely want a psychiatrist and or psychologist. For vision issues, look to either an optometrist or an ophthalmologist. For vestibular issues, ear issues, balance issues, look for an otologist or neuro-otologist. And then in some cases, you're going to also want a radiologist or a neuroradiologist. There is a concept that's been going around the plaintiff's bar where they have been using doctors who are specializing in diffusion tensor imaging. We'll talk a little bit more about that. But if you come across a potential plaintiff's expert that is relying on diffusion tensor imaging to opine that the plaintiff has suffered a mild traumatic brain injury, then you're going to definitely want a radiologist or neuroradiologist. So let's talk a little bit about, well, actually, let's go back just so, I don't know how many of you have come across diffusion tensor imaging right now, but it is a form of MRI. And it's based on the ability to measure the relative diffusion of water in the white matter of the brain. And the relative degree of the directionality of the water in the brain is measured through this diffusion tensor imaging as a functional anoscopy. Now, what you will find, and we'll talk a little bit more about this, is that people with a history of ADHD, ADD, autism, the diffusion tensor imaging, these type people will have abnormal water or relative diffusion in these imaging. So that's why it's important that you know what this plaintiff's history is. So
psychiatric problems in general.
Very good. Thank you, doctor. Yes. So some of the mental health issues to keep an eye on are memory, sensory, concentration, anxiety, depression. For vision issues, you may come across photophobia, convergence disorders, saccadic eye movements, For vestibular issues, you may come across dizziness, balance, feelings of floating, the plaintiff may complain of, or blurred vision. So those are all things you're going to want to look for in the medical records and make a determination from a defense perspective whether you need an expert to address those. Okay, now let's talk a little bit about how can we attack the plaintiff's expert at trial. Now, again, many of you are very experienced defense lawyers here. These are just a few of the things, but especially when you're dealing with plaintiff's experts, I am always amazed at how little the expert has actually reviewed of the plaintiff's medical records. And it's amazing how many of plaintiff's experts have not reviewed a plaintiff's pre-accident, pre-injury medical history. And there's a lot of fodder there to go after them. Look for in the medical records as well the descriptions of the incident. I will guarantee you that the plaintiff in an MTBI case has described the accident they were involved in several different ways. You will usually find at the beginning a somewhat vague type description, and the description gets more dramatic as time goes on and the plaintiff is treating more. And then compare that with the description of the incident that is that the plaintiff's expert describes. And in many cases, it is completely different. And it gives you as a defense lawyer good cross-examination as to what this expert, what his belief was as to how the incident occurred. And then you can go back to the prior medical records and show that the description has changed dramatically over time. Okay. The extent of plaintiff's pre-incident history, again, it amazes me how many experts have not looked at those prior records and have no clue as to a plaintiff's prior psychological problems they may have, or other mental health issues the plaintiff has had. Many plaintiff's experts, their testing and their opinions are heavily reliant on the plaintiff's self-reporting. Okay, they take the plaintiff's word at face value. And of course, you as a defense attorney can point that out at trial, that this is what the expert is relying on, that what the plaintiff told them, and not what the actual medical records through time have shown. Also, keep in mind when you're at trial, always ask the plaintiff's experts which of plaintiff's providers they have spoken to. The answer is usually none, okay? And that gives you, again, just some cross-examination fodder at trial when the expert says, well, I have not spoken to any of plaintiff's treating providers. And then you just can go after them as, why not? Isn't that important? You simply, again, relied solely on what the plaintiff told you. So again, many of you know this, but it's always good to have a reminder. Also in attacking the plaintiff's expert, again, diffusion tensor imaging, all right? This is becoming vogue. And some of the things to keep in mind if you're facing this is DTI. It is not something that is relied on by radiologists or neuroradiologists in diagnosing individual patients, because it is not generally accepted for evaluating and treating individual patients. It is used primarily for research, okay? So those are some areas where you can attack diffusion tensor imaging. I've come across this type of testing on a handful of occasions. I have filed Daubert motions to try and get it out. I have been generally unsuccessful in doing that. So you got to be prepared to attack it at trial. And this is where a neuroradiologist can be helpful. And we use in the trial that you heard Sheila discuss, we had such a person, a neuroradiologist, that helped us attack the DTI that was being shown. For functional neurology or chiropractic neurology, well, you know, Oregon has now allowed chiropractors to be chiropractic neurologists. And so you will be fine, you may come across some of these people. Some of the testing that they use are things like computerized dynamic posturography, video nystagmography, head impulse testing, all to try and show that this plaintiff suffered a traumatic brain injury. Now, what you want to keep in mind with this type of testing, and an expert in this area can help you from a defense strategy, is that the vast majority of studies on these types of testing, in essence, tend to show that the validity and quantifiable reliability for diagnosing concussion is questionable. And I don't know, Dr. Binder, if you've come across this same kind of testing, but there is studies in there that you can find online and work with your experts on, and you can attack these types of testing to show that their validity and reliability is low for actually trying to diagnose when someone has had a mild traumatic brain injury. Typically, plaintiffs' experts will include a psychiatrist or a psychologist or a neuropsychologist. Some of the testing that you will come across is things like the Wechsler Adult Intelligence Scale, the Symptoms Checklist 90, the Beck's Anxiety Inventory. Those are all, in essence, self-reporting type testing. They do not have any validity testing built into them. So you want to be aware of that. Although these tests sound, you know, great, you read a report and you see a psychologist or psychiatrist that have given these tests, you look at it and you think, oh my God. If you start digging down into what these tests do and whether or not there is any validity testing to them, you will find that there isn't. So some of the tests that do are things like the MMPI, okay, the Minnesota Multiphasic Personality Inventory, or the Personality Assessment Inventory, or the Millen Clinical Multi-Axel Inventory. These all have built-in validity scales. So your expert from the defense perspective will likely be giving those types of testing to the plaintiff in an IME, and you'll be able to attack the plaintiff's experts who has relied on these to diagnose the plaintiff without validity testing, and these other ones that I just mentioned that do have validity testing. Okay, some of the learned treatises you might come across. It's interesting. I've had a couple cases where the plaintiff's attorney has tried to get the court, actually the judge, to take judicial notice of the reliability of some of these publications. Universally, they've been unsuccessful in doing that, but many of these learned treatises, if you will, they do deal with veterans and post-concussion mild traumatic brain injury in wartime scenarios. And from a defense perspective, I have been successful in motions in limine to keep these out because they do deal with veterans. And most judges have agreed that studies with veterans in wartime situations is not analogous to a car accident or a slip and fall. So keep in mind that if you come across these types of publications, you should have a relatively good shot at keeping them out. I want to just highlight this. The CDC fact sheet, sorry about that, for physicians about mild traumatic brain injury. Okay, this is you can find this online, but it's a document that on its face looks to be kind of because it's from the CDC, and plaintiffs will use this. They have a list of symptoms in this fact sheet, and plaintiffs' attorneys, the good ones, have been very effective in using the list of symptoms that are supposed to identify or be analogous to post-concussion syndrome or mild traumatic brain injury, and going through with the defense expert each one of those symptoms and getting the defense experts to say, yes, I see, yes, 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 to each of these symptoms. And it's usually plaintiff has complained of this, plaintiff has complained of this. And so they want to try and use this CDC fact sheet. However, you're going to want to go to the footnotes, right? This CDC fact sheet relies on multiple other publications, and you're going to want to educate and make sure that your expert is aware of this CDC fact sheet, because I've been seeing it used more and more, and make sure they go through and look at the publications identified in the footnotes, because there are all kinds of qualifiers and qualifications with respect to what is being stated in the CDC fact sheet. So those are just a few things that you're going to want to be aware of at the time of trial. So the IME, let's just talk a little bit about that. I know we're getting close and running out of time, and some of you may have questions. Make sure that you understand the testing that not only the defense experts may be performing, but make sure you understand the testing that your own experts are performing. Okay. Pros and cons of videotaping. Well, me personally, I really have no problem having an IME videotaped. Now, certainly if the expert, the doctor you're using, does not want to have that happen, that is fine. But I, at times, have, if the plaintiff is not going to videotape it, I at times have, and I've hired a professional videographer, and I've had him videotape it. And you can use that at trial at times very effectively. And I have at times shown clips of an IME so that the jury can see exactly what the plaintiff was doing and how the plaintiff was acting. Because in many cases, they're either going to be overstating their symptoms, or they're going to be in a situation where they are acting much differently than how they describe themselves acting at the time of their deposition. And that's another thing. You're going to want to always videotape a mild traumatic brain injury plaintiff during the time of their deposition. And if you videotape the IME, many times you will see a stark difference between how they are acting, and you can use that at trial. There's been more and more attempts. For those of you that practice in Washington, right? Plaintiffs' lawyers are always trying to put conditions on the IME, and you're always trying to have to fight that. But it's getting more and more now in Oregon. Just a couple things to keep in mind when a plaintiff's lawyer is trying to put conditions on the IME. First, remember the Multnomah County Consensus Panel statement on ORCP 44 medical examinations. It addresses recordings, recording the exam. So you have authority through the consensus statement on when an IME can be recorded and when it cannot. So keep that in mind. There's also the, many of you are probably aware of this, the Lindell v. Kalugan case, if I'm pronouncing that right. It's a 2013 case that has made it clear that in Oregon, it is the plaintiff's burden to establish good cause for any condition they want to put on an IME. So it is not your burden to fight a request for some form of condition and show why that condition shouldn't be imposed, but it is the plaintiff's burden to show good cause as to why it must be imposed. So keep that in mind. And then there are also some federal cases. Now, Oregon's ORCP 44 exam is based in part on the federal rule. And so federal law is persuasive. And I've been pretty successful in convincing the court that they should follow the federal court's rulings on this. And probably the most relevant case is the Romano v. Tomorrow Inc. case. It's a 1997 District of Oregon case, 173 FRD 271. And that addressed various restrictions that the plaintiff's lawyer tried to impose on an IME, primarily relating to the doctor asking questions, medical history questions, and filling out a medical history questionnaire. So those are a few things that you can use to help overcome the plaintiff's attempt to impose, what we as defense lawyers would say are completely unreasonable restrictions or conditions on the independent medical examination. We're at noon, so I will stop.
That concludes the webinar. Thank you all for joining us, and thank you, Eric and Dr. Binder, for making the time to present to the OADC membership. And Dr. Binder, sorry you got dropped off and didn't get through your whole slideshow. So we're going to distribute all of the materials at, as soon as the CLE is over, and once we gather them, they'll go out to all the participants.